Hi, everyone. Welcome to today's program titled Compliance Iced Coffee, chatting about I-9s as we return to business. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. This session is being recorded. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to Leon Rodriguez. Leon, please go ahead.
Good afternoon. It's a pleasure to be here with everybody this afternoon for our webinar entitled Return to Business, Compliance Iced Coffee, chatting about I-9s. Turns out that one of our group here today really likes joining friends for coffee, and that's been a little hard to do lately. So we're taking this opportunity at least to imagine that we're all sitting around having coffee. Your speakers today are all of the co-chairs of the Seyfarth Shaw Immigration Compliance and Enforcement team. And they are, going from left to right, Masa Aliascari, and I would note that we have a bi-coastal group here, two in Los Angeles and two in Washington, D.C. Masa is senior counsel in our LA office, where she helps organizations identify, develop, and implement immigration sponsorship programs, and also counsels clients facing government investigations or audits, and works proactively with them to develop immigration and compliance policies and conduct internal assessments. You next have Dawn Lurie. Dawn is a partner in our Washington, D.C. office. She is one of a very small number of practitioners nationally who dedicate their practice exclusively to I-9 worksite enforcement and immigration compliance matters. And I love this part of her bio. Her inbox is constantly full of novel queries involving electronic I-9s, the ICE fine matrix, and remote employees or E-Verify structuring and SS no-match letters. She really is one of the true national experts in this area. Angelo is a partner like Masa in our LA office. He's one of the founders of the Association of Business Immigration Lawyers. He recently was named a fellow in the College of Labor and Employment Lawyers and has experience in a wide array of immigration subspecialties and is really looked to by many as an expert witness and consultant on immigration issues, not only in litigation, but also more generally as an advocate for due process reforms to America's immigration laws. And finally, my name is Leon Rodriguez. I'm a partner in the Washington, D.C. office. I served from 2014 to 2017 as the Director of U.S. Citizenship and Immigration Services, and before that spent most of my career as a federal and state prosecutor. Next slide, please. So our webinar today is really going to look generally at issues related to I-9 noncompliance, the risks attendant thereto, but then also really look at those risks in the specific COVID context in which we've now lived through since March. There have been a number of permissions and flexibilities that have been authorized both by U.S. Citizenship and Immigration Services as well as ICE, but even those themselves create a number of issues for employers seeking to verify employees in a time when part of your workforce is in the office, part is not, and where those circumstances really shift day by day as pandemic conditions shift locally throughout the country. So we're going to really work today to take a high-level view of those issues, go through the various permissions that are out there, identify some of the questions that you're going to have to ask yourselves, and really start talking about some of the risk management and mitigation strategies that need to be undertaken in this new environment. Next slide, please. So to look more specifically at what those permissions are and what's been going on here in Washington, D.C. Since mid-March. As the pandemic began to spread throughout the United States, and very rapidly a number of state and local jurisdictions imposed various quarantines, stay-at-home orders, shelter-in-place orders, and as a result, a number of workplaces went to either fully remote or partially remote. The Department of Homeland Security, and more specifically ICE, Immigration and Customs Enforcement, announced flexibility in order to comply with requirements related to Form I-9 as a result of COVID-19. And basically what this authorized was for those workplaces that were fully remote, employers would be able to conduct inspection of documents and prepare Section 2 remotely, with the employee being in one location, the documents being in that same location, and the verifier being somewhere else. And that could be done either by video, by fax, by email, all with the expectation that ultimately a live inspection would be conducted at a later time. And there are also some ambiguous instructions for those workplaces that were not fully remote, that had something more than a skeleton crew in place, indicating that decisions to conduct remote verification in those cases would be looked at on a case-by-case basis, which introduces, of course, a lot of uncertainty and complexity for employers. And so that was initially authorized for a period of 60 days. It was reauthorized for 30 days in May, reauthorized for another 30 days in June, and finally, just this past Monday, authorized yet again for those. For another 30 days, taking us into August, and not clear where we go after that. In addition to those flexibilities, there was an initial extension of time for those who otherwise would have been on a 3-day timeline to respond to Immigration and Customs Enforcement notices of inspection. There was an extension there for 60 days. That extension is no longer in force. So any of those that were due in March have either already been turned in, are now due and owing, or you've, in some cases, perhaps you've worked out additional accommodations specifically with your auditor. But those sort of blanket suspensions of those due dates are no longer in place. And with that, I turn over to my colleague, Masa.
And before we go to the next slide, real quick question, though. If you did have a notice of inspection from March, would you have had those extensions as well? Because I think that was one of the confusing points of how the extensions applied and when they applied, depending on when the notice of inspection was issued.
So what had been my operating assumption was that if you received a notice of inspection in March and did not respond to it, so that's a key element. So those who already started responding really could not take advantage of the suspension. That then you did have that automatic 60-day extension in place. I mean, curiously, agents continued to work during that period. So they actually were, in some cases, eager to wrap up the audits anyway. I remember one particular case where they came back with a result. Fortunately, in the case involved, it was a clean result. but where agents were continuing to work and continuing their audits during that period.
So Masa, just to clarify, I think what you may also have been asking is if you were served earlier than March. But what I'll say is there really weren't any, there wasn't a lot of NOIs that were served in January and February. The surge started the beginning of March. So if you were served in January or February, it was because something special was going on. We didn't have any of those. But no, they were all served in March, and they were all there. And frankly, you know, I think what headquarters had told their agents and their auditors were use this time to catch up, because we certainly have things that, you know, are in some cases going back almost 2 years where we haven't, you know, where they're open. We're hearing from colleagues outside of the firm as well.
Yeah, thanks for that clarification. I know that with all these extensions and expirations of extensions, people have been really confused about when am I required to make my submissions and responses. But looking at this next slide, really, there's a lot of musts here, right? We know that they try to understand and give us options for how we're going to comply with the I-9 regulations, given that they don't allow us to do remote review or electronic review in normal circumstances. So let's unpack some of this and see how everyone is kind of addressing each of these musts and requests and requirements if you are remote. Remember, this only applies to you if you have gone remote, have had your workforce go remote. So Dawn, talk to us a little bit about what this means to virtually copy and retain your documents. And what that process may look like, or what you've kind of walked through some of with your clients and what they're doing and what really isn't complying versus what it could comply with the process.
Yeah, so ICE gave the opportunity for employers. They made it very broad. They said you can do video calls and you can use fax or you can use email to complete these I-9s virtually. And we have some clients that assume that you could use a combination of both. The bottom line is you have to retain documents. You've got to do the virtual within the 3 days of someone, you know, onboarding. If you're doing a re-verification, it still has to be done before the person's documents expire. And in the case when you're, you know, taking documents, there's a lot of things to think about, right? Because how are you getting the documents? Are you taking a screenshot if you're doing a, you know, a FaceTime call, or you're doing Zoom? Are we taking someone holding it up and, you know, putting it to the camera and saying here, and then you're taking a shot? Things that we're finding that clients haven't thought about or companies haven't thought about are how are they getting the Section 1? So in this process, you're having the employee complete Section 1 on or before the first day of work, and then the employer has to complete Section 2 on or before the third day, virtually. So companies have to think about, are they going to be sending out a FedEx label and having the employee send the original to the person who is sitting in their house completing the I-9? Is it going to a company address? Is it going to a P.O. box? And these are all the things. But at the end of the day, you need to take those documents, you need to keep them. One of the things that we're also finding out is there are some of the vendors that are not set up to accept documents. If you have an instance with some of the vendors and you're not, you didn't choose to, you know, to copy documents before, they're not able to switch you over, or in some cases, they're only able to allow you to accept documents if you have a E-Verify. I mean, it's silly. These are all things that need to be thought about. So there's a lot.
And there's really a question of how your process really needs to mirror what you're using, right? Versus a hard copy paper I-9 process, and that's what you're still doing, your hard copy I-9s, or did you move over to electronic I-9? If you're in an electronic I-9 scenario, perhaps the question of how are you collecting your documents is addressed relatively easily because they're uploading them into that system. But what if the system's not set up for that because they assume that the person would be standing in front of you and you wouldn't be, and you haven't collected documents, so you really don't know how to do that process through your vendor system? Or if you're hard copy, are people emailing it to your HR folks who are completing it, and then are they saving it on their desktop? And then do you have protocols for that, for deleting it and making sure it's removed so it's not accessible to anybody else in the future? So there's a lot in there. It's not just as simple as, oh, now you can do it through FaceTime, right? There's a lot more questions that come up. And then what about companies that are starting to come back on and bring their workforce back? So they're no longer fully remote. Maybe they start with a 10% phase one and move up to 25% and so on and so forth, versus a company who said, you know what, we're staying remote until 2021.
It's a lot. I mean, the bottom line is either you have to have an electronic system that's going to track all this for you, and maybe you need a build out. Maybe the system that you have isn't sufficient. Maybe you're going to have to, even if it's just a spreadsheet, building a matrix yourself. Who's coming in? When are they coming in? I mean, one of the things that you'll see we recommend that isn't part of the ICE guidance is on the return to work to consider putting the return to work date in that additional information box so that there's no kind of confusion later on. But at the end of the day, somebody has to own this. We'll just kind of end this and move on, but someone has to own this. A team has to own it, a person has to own it, and there's got to be backup. And you really should be considering electronic systems or technology to help in this. There's just really otherwise no way to get through it unless you're a super teeny tiny employer and you can remember everything in your head.
And Dawn, as we transition to the next slide, let me just mention that it's really important that you use the electronic system you have properly, that many systems allow a sandbox where you can experiment and play with it. They have videos of training. They have printed instructions. So it doesn't help if your system contemplates you're going to follow a particular procedure and you don't.
That's exactly right. Or if they're not putting the resources. A lot of the vendors, if your vendor, if you haven't contacted your vendor and you don't know what's going to happen on the return to work, I mean, you need to do so. And then you need to hold your vendor to task. They've got to put the money and the time in it if they're offering it. It's a kind of get what you pay for kind of thing. A lot of the electronic systems are add-ons to HRS or payroll or whatever, and they are not in any position to be putting this technology out. So I've said this on our prior webinars, I'll say it again. I mean, this is really going to separate, the better systems from the ones that you need to consider switching. So we're going to move on.
And thinking about all those musts, and you have to make sure you comply. You have to create your own matrix. I-9s they were never simple, but definitely not now with all these different rules. What does it mean to not be compliant, if you can even understand what compliance really means at this point with COVID-19? But what does that mean for us if we're not compliant? And really, we're looking at some serious consequences for I-9 violations, and it's not just fines. Depending on the level of what's been done in investigation, you can look at criminal prosecutions. There are fines, and there's also debarment. So if you're a federal contractor, you really have to consider what does that mean for you if you're found to have violated these Form I-9 requirements. So you might look at a fine of just $230 for a paperwork violation, not a big deal, but there's more to it than that. And criminal prosecution, it can go up the chain, so it's not just people on the ground. And I don't know if Leon, Angelo, and Dawn, if you have any thoughts or comments on that.
Yeah, I have one quickly, and there's good old-fashioned brand damage. A recent announcement of an immigration discrimination settlement that involved a major law firm can be less than helpful. So be protective of your brand and your reputation as well.
That's right. That's right. And in these kind of decentralized times where people are working in places they may not, it's more important than ever to have SOPs so you know what your hiring managers are doing. And a lot of our manufacturing and other types of retail where maybe HR is not physically in their office, but essential personnel are working, and they're kind of doing things from a different location. What is it when the cat's away, the mice will play, or whatever. So ICE is aware of this. They're already all over these things. They're looking what's going to happen in the future. So let's just talk a little bit about the violations. On the hiring violations, these fines up here, the heavier ones, those are going to be where you have unauthorized workers, right? That's in your middle. That's where the fines can really get expensive. And the variance is there based on the percentage of unlawful workers you have, as well as whether or not you've been found to have an unlawful worker in the past. And by the way, an unlawful worker can also be somebody that's fallen out of status. It doesn't necessarily have to be somebody that, came in, undetected through the border. So keep that in mind. We're going to travel into paperwork violations and kind of look a little bit more at how ICE goes ahead and fines. It's a complicated and expensive process when we're talking about civil fines. You can, as I said, it's on the column on the left, this is the percentage of workers. So if you have 100 I-9s and you have 9 people that have a substantive violation and it's your first offense, it's going to be a fine of the 230, like Masa said. And that might not be a lot unless you have, 10,000 employees, and that adds up. And oh, by the way, if you have 50%, if you have 50 people, the fine goes up to that 1948. So when people say, what do you think the fine's going to be? I say, first of all, I'm not good at math, and second of all, I need to know the particulars. On top of this, there's something else that can change the fines. They can make them plus or minus 25%. There are 5 factors that can either mitigate or can aggravate. And Angela, there's a recent case that came out. A lot of people they get a fine from the government and they want to challenge it. I know a lot of the challenges are done by individual companies without representation. But tell us a little bit about a recent case.
Well, there's United States versus Eriksmoen Cottages. It was decided on July 15, and this caused the administrative law judge, and that's the judge who will hear an employer's request to have a fine reduced or to find no culpability. An administrative law judge had to apply the 5 factors, and those are the size of the business, the good faith effort of the employer to comply, seriousness of the violation, whether the violations involved unauthorized workers, and history of previous violations. And the interesting thing about this case is that the judge emphatically stated that good faith effort to comply only is going to be considered a positive factor to reduce a fine if it happens before ICE issues a notice of intent to fine. So now is the time to conduct whatever internal reviews you feel are appropriate and reduce your exposure before ICE knocks. The other thing is that this is a case that seems to go against what had been a historic and general trend of significantly reducing ICE's proposed fines. Here, the court found that even though there was no history of previous violations, and all of the employees were in fact authorized for employment, the court said that compliance with the law is an expectation and not an exception, and therefore not a basis to adjust the fines. The one thing that remains uncertain with this virtual I-9 era in which we sit is whether the so-called Sonny Bono amendment, the technical or procedural failure to comply, might somehow be used as a 10-day opportunity to cure errors that occur, and I think that'll be litigated.
So I have a question, just really thinking if I'm responsible for figuring out when to have people complete their I-9s in person, all these extensions and timelines, and I didn't set up a matrix, I really have no idea who's coming in. Where do you guys, any one of you really, where do you think that falls in terms of what is my good faith effort in this scenario where I'm trying to keep up with all these samples and rules and extensions, but, also internally, we have this rolling, back of our workforce coming back. Like, any thoughts on that? What would be good faith on my side if I'm doing this, if I'm responsible for it? Yeah.
I can suggest that not doing it at all is bad faith, and that would be equivalent to having no I-9s. So you can't just shelve the process until the pandemic subsides. Obviously, something after that is going to be a demonstration of what you did to try and correct the situation as the facts on the ground evolved. And so recording in some form of memorandum what steps you took will prove to be helpful later when you have to clarify to ICE what you did.
Okay, so what if I'm collecting copies of documents, but really I don't have a printer at home. We're a paper I-9. I'm not going to buy a printer to print out these I-9s and fill in Section 2 based on this. What if I just save it in the person's, on our system, in their personnel file? I've saved their documents, so we know we looked at it. We did what we needed to do, but I can't fill out the I-9. That's just not going to happen.
And you probably didn't get Section 1 either, probably, Masa.
Well, no, he filled it out. I'm not sure how he did it, and he emailed it to me with his documents, but I can't do anything from there. What am I supposed to do?
Well, for one, we've always said, even before COVID, that saving documents in a personnel file that relate to the I-9 is probably inadvisable because it could create an impression of some form of prohibited discrimination and may turn over records that are not discoverable otherwise in the I-9 process. So don't do that, but saving it somewhere, as long as it's retrievable and there's a record, I think will be helpful.
Well, I think you got to be careful where you're saving it, right? So if I'm working on my family computer and my 17-year-old, is also there and God knows what he's sending or doing or reviewing, or as, I just had a call with an HR manager who called and said, I have 2 roommates. I'm doing these, virtuals. Sometimes they're in the room. I don't have anywhere I'm printing them. I'm keeping them in my bedroom. What should I be doing? What should I be asking the company for? I mean, these are all things that you're right. I mean, there's no good answer, Masa, but what I would say is, like echoing what Angela said, do your best, and there's no excuse for not doing anything. So what you're going to have to do is you're going to have to make the corrections as soon as possible. So as soon as you find out that you're doing something wrong, you should pivot, you should memorialize, and frankly, if you're doing things wrong, you probably want to get counsel involved because there's just no one size fits all. That said, what I'm going to tell you is ICE continues to say we're going to look at this on a case-by-case basis. So if we pivot and then we'll end this and move on, if we pivot your example, Masa, where, you're not organized and you haven't done anything, and by the way, that would never happen with you, but if it was someone else, and then you added in the fact that HR is not on site and you have a manufacturing facility that's still operating, you have 250 employees, and by the way, you are supporting your manager because you have, out of those 250, you now have, 98 positive COVID cases, and you're dealing with this and production. Those are things that we're not going to remember 5 years down the line. Like, so if there are reasonable, I don't want to call it an excuse, but things that you can give to ICE and you can say, this is what happened, or we were doing it right and then we had this blip because XYZ happened. And then, by the way, to replace those 98 people after we closed and cleaned, we had to do a major hiring, and we didn't do this. We did it late. At the end of the day,
Dawn, let me just say one thing though. Really, this assurance from ICE that they will look at facts and circumstances. We've heard that line before, and we have decentralized I-9 enforcement. And so you're going to be at the mercy of an officer who happens to be knocking on the door with a notice of inspection.
Fair enough, Angela.
Yeah, absolutely. And I will say, to circle back to a comment Angela made in talking about this internally conducting assessments, it's a perfect time to do it after all of this ends, to do that internal assessment. See what you were doing, see what you need to come in and remediate once you're back in operation and you've got people on the ground to do it. And really, this goes back to this policy guidance from DHS. That's really what's left us kind of floundering, right, on the ground. What are we supposed to do? Because the direction is not really great. Leon, can you talk to us a little bit about what we've heard, what we're being told we can and cannot do?
We can't hear you, Leon.
I think you're on mute, Leon.
True, I was on mute. Yeah, so we had the March 20th guidance. That was the first announcement of the flexibility, and it gave some, decently detailed instructions on how to obtain verification documents, how to conduct remote inspection, announce the requirement to retain copies of identity employment eligibility documents, and also, I think critical from my perspective, gave instructions to employers as to how to mark the I-9 so that it's clear that the employer in that case is invoking the I-9 exceptions. In the guidance, as we talked before, and I think that Dawn has underscored, allows a lot of pretty expansive in the various ways it allowed review of documents, so video link, fax, or email. So it allowed a fair amount of flexibility. Now that said, it didn't relax the I-9 regime altogether, and so there still was a requirement to meet the timelines within 3 business days to obtain, inspect, and retain copies. Arguably, in an environment where remote inspections are allowed, it should actually be easier to comply with the 3-day timeline. It'd be interesting to see if that's how it actually worked. But there was that requirement to at least in that respect, to really stay true to what are typically the timelines and expectations.
So I'm going to play, I just want to play devil's advocate here. I'm thinking, and I'm not saying don't meet the timelines, because I think it's all going to go to good faith and it's going to help you in other things. But at the end of the day, what are they going to do? Fine you twice? Are you going to get 2 late violations, the one for the virtual, one for the other? I think what they're going to be looking for, this is just my guess, but I like to guess with them, I think it's going to be when you come back to work. I think that's what they're going to be looking at. But I think that this time is critical because it's going to show, like Angela was saying, it's going to show your good faith. And I think if you do it right and you show you're doing it right, that it's going to help you where there's discretion and on other things. I could be wrong, and who knows? They could.
No, I agree.
Right?
Also, from my perspective, it's kind of cumulative. So, if before the national emergency, your I-9s were a mess, and they're still a mess, a year from now when you get inspected, it's going to be a lot harder to sort of claim the COVID exception if in general your I-9s are a mess and your auditors, looking at them as a mess. So, I think it depends not just on what you did during COVID, but sort of everything else that you were doing before and after are really critical. In this regard, one of the areas where so the idea was that this the requirement to sort of return and to ultimately complete an in-person inspection occurs after normal operations resume. Normal is a moving target in a lot of ways. First of all, what does that mean? Does that mean normal from the perspective of the specific business, where it returns essentially to the same staffing levels it had back in March? Or does that mean something else? Does that mean, for example, if a portion of the workforce returns, does then that kick in? But also the reality that we're seeing now this summer is as virus levels have begun to spike again and death rates have begun to spike again, a lot of major jurisdictions are now returning to the kind of shelter-in-place travel restrictions that we were seeing through a lot of the spring. So that means that they may have resumed normal operations, and now that they have unresumed normal operations in a lot of places. That could get worse as we move into the fall and colder months. And so that's going to throw a lot of confusion in there. One of the things that I know we're going to talk about later on, I think there could, unless ICE ends up taking a fairly forgiving posture, which is possible, but I don't think we can count on it at all. I think we're going to see tons and tons of litigation in the period as these I-9s from this period begin to be the subjects of inspection. And so one of the things is people are responding to inspections when they start happening. is to have an idea of sort of what is basically going to be ready for different ways that those inspections might go, to begin engaging with the auditor, but also preparing for what could be, could be some tough sledding ahead. USCIS also issued some clarifying questions and answers. I gave a number of examples in order to illustrate how this would be undertaken.
And let's talk about exactly what those examples help or don't help with. Dawn, can you walk us through that a little bit?
Yeah, so we started to talk about that on our last webinar. And Leon, you're so nice. I mean, you're always nice. You said things are clear, and they gave us, and you're giving them the benefit of the doubt. I mean, look, I think the initial guidance from ICE that was issued in March, I'm very pleased with how much they gave us and in the time frame they gave us. I mean, frankly, they acted, before many of the other agencies. Could they have acted faster? Sure. But by now, I would have expected more clarity. We got those 6 examples, 4 of them having to do with the virtual, and then 2 of them having to do with the List B documents. And if you're not familiar with them, you can go to our blog, www.bigimmigrationlawblog.com. We have a lot of articles that have postings and kind of discuss what's going on. And USCIS has a great, totally revamped webpage, so it's sometimes a little bit hard to find, but on I-9 Central and on E-Verify, there's a what's new, and they'll talk about, there's a COVID place, and you can see on all I-9 stuff. So what happened was USCIS gave out these examples, and we started to discuss them. The problem that I'm seeing is, first of all, I don't necessarily know that ICE was a part of those. I have been hearing from so many different places that ICE is interested in, maybe in conjunction with CIS, to further issue additional guidance, more guidance on some of the nuances, because there are a lot of nuances. So every time I look at one of those samples, I find, something else that they didn't think about. Now is the time to start talking to your electronic vendor, or to put a process into place and to kind of go through what it is that you are expecting when a person, comes back to work. So what the guidance, talks about is, after the document review, you're going to enter in the additional information field of COVID-19. Actually, before you get to that, we're talking about the return to business, but I would suggest that you're not only putting COVID-19, you're putting it, when it's done virtually, you're putting COVID-19. I have people that, if you can put more language in there, they can say, view documents virtually, not just COVID-19. I have many HRs, a surprising number of people that have called me and said, I am very uncomfortable signing the Section 2 because I did not see these documents, and what if someone says I did? So in that case, I just say COVID-19, virtually reviewed. You can add in the, language. But once they come back, the guidance is saying, put in the information on documents physically examined and the date of the physical examination and who conducted it. The other guidance CIS talked about, as I said, was the expired List B documents and when you needed to, update and when you don't. We'll talk about that in a minute. I think here, we're not going to dig that far into the particulars because I could probably talk like a half hour on each one. But it's important to know what your scenario is. If you have an electronic I-9 system and it's not letting you record the title, right, you have a problem because the guidance says you have to record the title. If the electronic I-9 system's audit trail, which is mandatory, isn't recording who is putting that information in the additional information box and when, and if there's no, ability to trace that back, I think you have a problem. The one call out that I want to make here is I think that ICE is going to change their guidance, and I think what they're going to ask for at some point, and I think, frankly, it's a best practice even for companies, with or without it being mandated, is if the person is different, and really most of the time for most of our companies, it is going to be a different person that saw it virtually versus who's seeing it in person. If that person is different, I would offer to you to consider doing a new Section 2. And the reason for that is not only will the government see who's signing under penalty of perjury, you're going to see. And depending upon that industry that you're in, don't you want to make sure that the person who is acting on your behalf is doing what they need to do? So it's something to consider. If the government changes their guidance, I'm sure that they'll grandfather anything that's been done prior to that. But it is something to consider. So I just, before we go on E-Verify, I wanted to just remind people that E-Verify is basically telling us run with your time, okay? Run within the 3-day period. So if you're hired on a Monday, you should be running your query, even with the virtual documents, by Thursday. So I see a question where somebody is asking me to talk about the new Section 2 again. So what I said, just to repeat, I know it's a lot to swallow, is if you have new documents or a new I-9 completer, I am suggesting, and we'll look at some of the specifics on some of the next slides, I'm suggesting that you consider completing a new Section 2. And those of you who work with me know that I hate starting a new Section 2. I always say, try to correct, try to keep it. You're still going to need the original. You're going to need the virtual. You're going to have to connect them. And if you have an electronic I-9 system, they have to be connected in the electronic background. Somebody has to do that for you. But I just think it's going to be a lot cleaner. And as a best practice, not only will the government have a signature under penalty of perjury, you know that the person who said they're doing it has done it, in person. And there's not going to be any question because they're going to sign that certification, which is at the bottom of Section 2, and that's what I was talking about. But on E-Verify, again, the USCIS has said that they put an accommodation in their system to take the expired List B documents, and they also have extended the TNCs, not the time frame. A lot of our companies are misunderstanding that. You still have to notify the employee as soon as possible, but we're seeing in the background, they understand that some of the Social Security offices are closed and that they're letting, TNCs sit a little bit longer. So that's something on that. On the Social Security, I want to bring up something Mass and I were talking about earlier today. We have seen in a number of cases where someone gets a Social Security TNC and they contact, instead of going in, they contact them by phone, and they're told, especially in the case of the passports, that's what we're seeing, they're being asked to send in their original passport. I'll throw that out there. Anybody think that anyone should be sending in their passport to clear the TNC on the panel?
Yeah.
Dumb idea. Dumb and dangerous.
Passport. Yeah.
Yeah. Don't send in your original passport unless you want to go and apply for another one. Just a really bad idea. Send a copy in, or just tell them you can't respond, and you'll go in person when the office is. I haven't seen one TNC go final. I haven't seen one tentative non-confirmation in the E-Verify system go final. If this is still open, so I think it's fair to say that. That they understand we're not going to be sending those in. So we're going to talk a little bit about List B documents here. And again, we covered this for those of you. Thank you for joining us in our prior webinar. The thing about List B is a lot of the Department of Motor Vehicles are not open. A lot of government agencies are not open. So a List B document is an identity document. It is the part of the I-9. It is the part of the I-9 that actually proves somebody's identity. So List A is something that proves their identity and work authorization, like a U.S. passport or a green card. List B only proves identity. So that's going to be a driver's license, a walking ID, a government ID, a student ID, something that either shows a photo or has a physical description, color of your eyes, your height, your weight. By the way, if you're E-Verify, your List B documents must have a photo. And then a List C is a document that shows your work authorization. So because of what's going on, USCIS very graciously allowed, and I've never seen this before, they are allowing us to take expired List B documents. Frankly, I don't think ICE really cared, because I think that, you know, the common sense thing is there that nobody's going out and buying, you know, going to a vendor and asking for an expired document to be made and, you know, pay for it to show a fraudulent expired document, but whatever. So what they've said is if your state has already extended the expiration of the driver's license, if they've said you can, you know, continue to use it, then that is a solid List B document. You're going to record it. You're not going to re-verify it later. All you're going to write is COVID-19. Okay, so this is what the additional information box is going to look like. And by the way, you're going to write COVID-19 often if you are a person that's doing I-9. So if it's a List B, it's expired, and the state has said it's expired, that's fine. If you're number 2, beginning on May 1st, what they've said is if there's no extension, we're still going to let you keep it, because even though your state's being difficult, we understand that employers may not have any other options, or employees may have nothing else to present because documents, maybe they're not able to get to them. So they're saying if there's no extension, you can take it, but you're going to have to treat it as a receipt. I mean, you treat it as a receipt. It's not the same receipt exactly that you would have in the like a replacement receipt. You will have to the employee will have to come back in after ICE ends the policy. By the way, this is another. I'll throw this out now. This is another part of this process that's very confusing. People are thinking it's different things. There's one date. Everybody in the United States will have to, every company will have to have all those receipts completed within 90 days of ICE ending their policy. It's not when you return to work. It is within 90 days. So this isn't really the virtual part. This is just the expired documents. So right now, 90 days from the August date comes out to November 18th. Maybe
So hold on, because I'll admit, I am not keeping track of every DMV extension or not extension across the country. As a matter of fact, my mother-in-law was visiting us yesterday to see their grandchildren at a distance with their masks on, and mentioned she's renewing her driver's license. It's expiring, and she has to get a COVID test before she can go in. And I said, wait, isn't it auto-extended? I just assumed it was. But I'm an HR, and I have people all over the country who we're hiring and we're onboarding, some in California, someone in New York, some in Texas. How am I supposed to know what state is doing what and what's being auto-extended? And then I have to also keep track of when ICE is ending this policy to figure out my
So if you want me to tell you that USCIS has a place you can go to and they're tracking, no. As a matter of fact, some of colleagues that I work with a long time at some of the agencies have asked if I have a list. So we've been sharing, you know, among the tracking. But I came across a fantastic tracker. The Department of Defense is actually, and the link is right under here. They're tracking, and I can't switch to that screen, but basically it has every state. It has a link to the state's website. It tells you what the processes are, and it also tells you if you see something wrong on it and you need to update it, it gives you an email address. So they're tracking many other things.
And Dawn, that's tracking of driver's license expirations.
Drivers and government IDs, that's right. This is only for that. Okay. By the way, they are tracking other things, but I haven't had time to look at it, so there may be other government identifications that may be tracked. So it's a fantastic link. It's the Department of Defense. I would highly recommend it. Now, what I'm also recommending is that you download it and you save it so that you can say, this is this is what I relied on, and here's the link. You can also download the individual, like if you have all your hires, I'm in DC, most hires are going to come from Maryland, DC, or Virginia. I'm going to download that. I'm going to keep that with the I-9s, right? And then you're going to put all that information.
Now, Dawn, just to clarify, when you were talking earlier about what is going to be a receipt that's not really like a receipt, surely that must be explained now in the Handbook for Employers, the M274. Is that right?
You and Masa, really, you want a lot, don't you? No, no, there's no, go to that page, to their credit, let's give everyone a break. To their credit, they're tracking at least everything on a web page. So there is no guidance that they're not amending the M274 for these temporary COVID policies, but they are recording them and they are there. And in terms of
well, wait. Why should we give them slack? They just had their furlough extended.
Right.
I mean, the delayed. I said they've got plenty of time to work.
Right. That's right. That's right. Because this is as if they don't have other things to be doing, right? Like maybe they could be adjudicating our EADs and our perm res cards and getting those produced. But at the end of the day, it is what it is, and we just have to kind of work with it. So this tracking mechanism, the better electronic I-9s will track. If you are paper, and we have some very large companies, very, very large companies that are still paper, and they have really, really good people that are running the show. I always wonder what's going to happen when, Susie leaves or Lisa leaves. But right now, you need to make sure that the Susies and the Lisas are actually putting all this together and tracking. So yes, Masa, you are going to have to follow this policy. Read our blog. You'll know when it's extended or not extended, and you are going to have to then go back in and ensure that you actually come up with your updates if it is considered a receipt.
Or tracking, and what does it mean for us when we're completing our I-9s? Let's say we figured out how to track our timeline. How are we actually completing our I-9s? Do we know?
That's right. Are we doing them virtually or not? And that's something you'll see that in our next slide. This is an example of what we were just talking about. This is somebody whose ID expired on March 5th. They were I-9'd. They were a new hire on May 18th. And when they were hired, the government says, right, COVID-19. Now, here, it's a COVID-19. This is not a COVID I-19 for virtual. This is a COVID I-19 for the List B. This is why I'm saying we are suggesting that you just don't write COVID-19. You write COVID-19 List B extension or expired List B extension, because it's going to be really hard for somebody to understand what's the difference. What's this COVID-19 for? And, my eyes, I look at this right away. I can see this is expired, this isn't. Somebody else looking at this is not going to see it the way I saw it. And a year from now, 10 days from now, you're not going to know what this was and what you needed to do. Was it virtual or was it expired? So this is what the government says. We say explain. Put more in that COVID-19. Use your additional information box, okay? Even if your system, by the way, if your electronic I-9 system will let you do this for some reason, print it out, handwrite it, upload it in as an attachment so that somebody else, you're doing us a favor for helping you in the audit later on. When the person comes back, so this person presented a USCIS government ID card, it's kind of funny, and now they're presenting their updated card that now expires 6/15. Well, first of all, USCIS, in your example, this is not my example, this is their example, where's the issuing authority? They're just putting down the ID card, the document number. This to me looks like they're recording a new document. I think that this is a substantive violation, but if they have a copy, it'll become a technical. So I think they did a bad job with these examples, and I hope that ICE and CIS come back and give us more. This is signed by TJ. I'm going to assume that it's just the initials because TJ was the same person, he's the person who completed the original I-9, right? So he was the person conducting, looked at the original document. That's why we don't need him. Now, if somebody else, the way you're looking at this, to me, this is not a virtual I-9. This is somebody who physically came in and gave an expired document, because I don't see anything about it being virtual too. If someone else sees the documents, they're going to want to see their name. So it's going to have to say, T. Jefferson here. Now, what about when the person actually also has done this virtually? They didn't give us an example for this, so I'm going to give you one. I'm telling you, I think you also have to put remote inspection completed on this day, and I think then you're also going to have to say when the documents were physically inspected. I think you're going to need both. So this is complicated. You know, if you're sitting there going, wow, this is a lot. Yes, it is. These are all things that, you know, we need to think about. We need to understand. We can't just go off of the the USCIS suggestions. These were just kind of things that they gave us, but it doesn't mean that it's the be-all, end-all, or that it's, you know, actually correct. So to kind of sum this all up, we need to know who did this, whether or not it was an expired document, and whether or not there's another action item on this. And I think it's a lot, and I'll turn it open, you know, to the other panelists here if there's, you know, any, you know, other thoughts. We're going to go to the next slide that people can be looking at as we're kind of discussing. This is for someone who is where we have a different person completing. But any suggestions or you know, comments or concerns here with what we're dealing with ICE and CIS?
Well, Dawn, if you go back to the prior slide, I will just say, looking at it, I'm seeing multiple dates: 3/5/2020, 3/30/2020, 10/1/2020, 5/18/2020. It's all very confusing to me, and I'm getting cross-eyed just looking at it. So I can only wonder what people having to complete these are thinking.
And that's good, because I noticed that when I did the sample, I should have said remote inspection completed on 5/18 up here, that above the red arrow. I thought if I was actually doing this as a real sample, or, you know, a real I-9, the remote inspection, had it been, it would have matched the date actually that you can't see below, but it would have been, you know, sometime in March. And I guess actually the date you can't see that it was signed could be in March, and the start date could have been 5/18. So it's a lot. This is not going to be easy, folks. You're absolutely right. This is it's going to be hard, especially for individual companies that have large workforces. Yeah, that's the problem. Okay, so let's go on and talk about the physical inspection by a different completer. So if you look at the first, the top box, this is what CIS gave in their example, and it follows generally what ICE had said on day one back in March. It says, you know, you have to put the rote inspection completed on the date, and then when the person physically comes in, you're going to put down documents physically examined on the date, and then the title of the person and the person themselves. Now, it doesn't say that you need to put your initials here. It's implied that the person who's writing this is the same person. But if it's a different, or the same person whose name is here, not the same person who did the original. So it's implied that Betsy Ross is actually doing this. In the context of an electric I-9, I've seen systems where somebody else can actually execute maybe the person's typing this. In some systems, I'm seeing that somebody else can basically record this. I would not suggest this. So somebody else alone is saying that Betsy saw this. I think, you know, maybe we can make an argument later on if that's how it was, but I would suggest that the person either log into the system, sign their name, if you're going to do this. The stepping back to what I said a few slides ago was, if somebody else is seeing those documents and you're not the person who put your name in Section 2, you may want to forget all this and you may want to just complete a new Section 2. That's just going to be the easiest, cleanest thing. But if you are going to do this way, I would suggest that you add information. I want to see that COVID-19, right, while you're using the physical. And then you may want to put when the person actually returned to work and when the documents were examined. So here we're recording that the person comes back on October 21st, and Betsy is actually looking at the documents on 10/23. If you're, go ahead.
So just in the interest of time, Dawn, I'm going to just comment that really these are examples, and I wouldn't suggest that anyone take these examples and then apply it across the board to what you're doing.
Exactly.
How you return to work and how your current system and processes are set up will really inform how you're going to complete this Section 2 in person as you bring your workforce back. These are samples just to give you an idea and help you understand that there really is a complexity here because USCIS and ICE haven't been as helpful with their guidance, and they're also not talking to each other. As you can see, USCIS is missing what ICE will probably pick up in an inspection in terms of their guidance and the samples that they're providing. So really important. And that really leads us to kind of bigger picture beyond these in the weeds kind of what it is that we're doing to talk about changes in policy and how we can use this time and what we're seeing happening and the trouble organizations are having to really drive policy change and how we can do that. And I know, Dawn, you had one more comment before we go into that.
Yeah, I got a question. We talked about returning to work, and what about companies that know that they have employees that are never going to return to work? So it's happening a lot with interns. They may have started out, they thought they were going to be coming in August, and now the company's not going to return. So I think, again, just like you were saying, Masa, there's no one-size-fits-all policy. You really have to look at the particulars and look at the timing and whether or not you should have, maybe an authorized representative to it, or you should be, not using the virtual method. We're going to have to be careful. I mean, really what you said just resonated, and it should resonate with everyone. There is no one-size-fits-all policy. This is complex. I wish it was easier. I wish they were not making our lives very, very difficult at this point, and I wish there was not so many it wasn't such a suck-up of resources. Frankly speaking, I think that Homeland Security Investigations, HSI at ICE, I think that this is a thorn in their side too, and it's not really where they want to be putting their time and energy, but it is what it is. And so this is a great segue into policy. What can we do, and what's going on here now?
Angela, can you kind of start this conversation, this part of our conversation, in terms of what we're experiencing as challenges given the pandemic and the remote work, and what we think will lead to policy change, or what we hope will lead to policy change, given that we now have kind of these hard facts and experiences to use to drive that?
Well, gladly. As everyone has noted, this is a befuddling process. No one expected it. It wasn't designed this way. And there is still a very unclear concept that has not been explained by either ICE or USCIS as what is the resumption of normal operations, and what does return to work look like, and will it be accepted in multiple flavors? Since none of that had been thought through in advance, no one expected to have to come up with this policy on this compliance conundrum in advance. We're going to have to do our best and try to demonstrate that the behavior was reasonable under all of the circumstances. That means we become something of archivists in terms of recording what we decided, what we thought about, why we did it a particular way. And most employers I know have more to do than archiving historic events. And so seek out counsel, come up with some protocols on how to deal with this. Try to be as consistent as you can, and if you have a large, sprawling organization over multiple time zones and geographies, try to get everybody on the same page.
Looking at the regulations and why we're having such a hard time, when were those regulations implemented on I-9s? I know that they have the word microfiche in them, and I can tell you many of the people I work with now have no idea what microfiche means. So,
they weren't even born when there was microfiche.
Exactly.
I know microfiche.
So,
they don't even know what taxes are.
Exactly.
Well, they started coming out in the 1980s. They've been evolving with the I-9 electronic regulations later than that, but there have not been frequent regulatory updates. This has been announcement by policy manual and handbook and website, I-9 Central. It's involved liaison meetings that sometimes reproduce minutes. it's a mess.
It is,
and so
and there's no acknowledgement of changes in technology. There's no acknowledgement that there's FaceTime now. There's no acknowledgement of this real way to virtually complete the I-9s, and that's why we're in the mess we're in right now, right? Because the regs are so static and they're so outdated that we're coming up with all these ridiculous timelines when really our technology allows us to be compliant, complete our I-9s, and really do this in good faith without having to do it in person. And so I know one of the other methods, sorry.
I think we're going to say the same thing. That leads to a recognition that there is an accepted method known as authorized representative, and I suspect Dawn is going to talk about its pros and cons at this point, because it is a method that can theoretically work, but there are inherent risks associated with it.
Yeah, and I'll turn it back on the risk, because you always like to tell us about the risk. Which I agree with, but sometimes you have to weigh the risk, right? What's worth? So when we're talking about policy, these are company policies. Company policies, companies may need to pivot, especially now. So the virtual guidance was due to expire this Sunday. And on Friday, I was having calls with multiple employers. Is it going to be extended? Is it going to be extended? Now, we thought it was going to be extended. I mean, for Christ's sake, the government is not even fully open. The agents aren't even back to work, whatever. So we thought, but we also could only say to clients, hey, look, you need to be able to pivot. So Friday night, I was getting calls. I have 50 employees, 100 employees onboarding. I said, okay, calm down, because even if we don't get the guidance, or even if it changes, Monday is just going to be day one. We're going to do section 1, and then we're going to have a couple of days to be able to pivot. Don't wait. Of course, I love spending my weekends with each of you, but let's come up with a policy and a process. If you have to go to authorized representative, at least understand what it's going to be. So what that means is somebody steps into your shoes. You can designate, I can say, Masa, you're going to do all the I-9s for everybody in California. They're going to go into your office. You're going to step into our shoes. If you screw it up and you ask for too many documents, or you turn a U.S. citizen away, I'm going to be the one, the company is going to be the one that's in trouble. But I'm going to provide you with a process and an overview, and then I'm going to check everything. But you can see those documents. You can view them. You can take care of it for us. You can be our authorized representative, and then we're done. We don't have to, the company doesn't have to look at it again. So during the pandemic, we started to use this process, and we kind of morphed it. Some of the electronic I-9 providers have networks. Some people use notaries. There's a network. I don't want to speak ill of notaries, but just one thing I want to remind you. Notaries do not, when you become a notary, you don't get a course in I-9 training. My 17-year-old, I promise you, knows how to fill out an I-9 better than most notaries. Why? Because he's around it all the time. And notaries, you make it somebody who never saw the form. You don't need it stamped. It doesn't make it any more official. So using a friend or family member, especially during the pandemic, it was common sense. Now, for the jobs that were high risk, most of those essential workers, when I say high risk, people that were coming out of one industry and didn't have lawful paperwork and going into another, frankly, they were actually physically going in because they're doing jobs that are, require physical presence. So you don't even need to use the authorized rep. You were using the physical in person. But if you put together a friend and family member policy, and you have the right structure, you have the right gates, and you have a process to audit and an audit protocol, it can work. There's downsides. Angela, tell us about the downsides, why we don't like it.
Well, the government regulations say that the employer assumes all liability for error on the part of the authorized representative. And by definition, in this kind of geographically distant setting, the employer has no idea what transpired, no idea of how the actual situation went down and what was recorded on the I-9, whether it was recorded accurately or not, whether there was a wink and a nod between the parties who were in person as to what was shown and what was said, and it wouldn't come out until later unless there was a process of periodic review, assessment, audit of what each friend or each family member, in fact, did.
That's right,
So
and that's why you should have a mandatory
totally
copy
unmanageable.
policy. Well, I don't want to say it's totally unmanageable because we're managing it. We're doing it. We're doing it with very large companies. It is definitely manageable. You just have to spend the time to put the process together, and you've got to think about
I meant that in the sense of the first of the 12 steps. My life has become unmanageable.
I see. Okay, fair enough. So again, things that will help you. I would never authorize a friends and family model without a mandatory copy policy. Like, you've got to be able to go back in and look at the copies, right? So that we can help you, a third party can help you. We're actually working with vendors that are, helping come back in and look at fraud docs and things like that. E-Verify, right? You really want to be on E-Verify. You have to have bodies. You have to have time to be able to do this. So look, it's possible. I'm not saying that it should be our only method, and at the end of the day, we shouldn't settle for it, but it's something that we can work out and we can help put in place for companies. And for some companies, you're always going to have remote workers, so you should have a solid policy in place. And so as we move forward and everything changes, I really believe that 2021, maybe the end of 2020, is going to be the opportunity for us to kind of step in and to change things. So, Leon, what can we expect? What as employers are relaxing, their own requirements and putting other things into play, what can we get that we don't want to see? We don't want to only have the authorized rep and virtual. We want it to be one and done. We want a virtual, and that's it. We want it to be just all virtual. Is it possible? Can we do it?
Yeah, I think it is possible. I mean, I think there are two realities that are sneaking upon us and are going to need to sneak up on the government as well. And that is, as we speak, you can deposit a $10,000 check with your iPhone, and the bank will honor it and cash it, and the money will be in your account in a lot of cases within 24 hours. So we're doing some pretty serious transactions remotely that even 3, 4, 5 years ago we weren't. The other reality is
virtual notaries now, right? Virtual notaries.
Virtual notaries. We actually are in the process as a firm actually of enabling a number of our notaries to operate remotely. You can execute a will remotely here in Maryland where I live. So I mean, there's so many examples of really serious legal transactions that can be done remotely. And the other thing is that the remote workforce is not just something that we're going to be experiencing during COVID. It's something we were already experiencing significantly before. And I think a lot of businesses are learning during COVID that they actually operate very well and may even operate more efficiently and cheaply remotely in a post-COVID world, which means there's a good reason to think that the world 3, 4, 5 years from now will be far more of us will be working from home and hoteling than now. So that's causing a lot of employers, the employers that we interact with in our practice, to really be seeing a critical opening here to relax the physical inspection requirements. And for what it's worth, I mean, this is not necessarily specifically in the I-9 context, but this is something that I think certainly Homeland Security has been coming to appreciate, that technology is now at a point where sort of remote inspection of documents, in a lot of cases, either as reliable or even more reliable than a live inspection. It's also potentially a moment for total disruption. In other words, really in some way just eliminating the whole document inspection regime. I mean, we're sort of assuming that we're going to just move incrementally from the physical inspection regime to a remote inspection regime. That too is something that could change. And I think it's something that employers will want to do. Some employers are already mobilizing. And so the questions are, what are going to be the avenues for advocacy? And I think it's clear that in the first instance, it's going to be at the executive branch level. I think you made the observation earlier that, you know, Homeland Security investigations, it's, you know, busy investigating major customs violations and child pornography and counterterrorism. They don't necessarily want to spend all their time mixed up with I-9 inspections either. So I think a really clear first place to start is at Homeland Security, engaging with my former agency, USCIS, with ICE that has the enforcement piece, but also with something called the private sector office. And this is something that really goes back to the Bush administration. And Homeland Security was really designed to really wanted to design itself in a business-friendly way. It created the private sector office as really the voice of business within the Department of Homeland Security. And so I think initially these are going to be the avenues of advocacy. Then the question is, you know, what is the outcome that we're seeking? One outcome could be a regulatory change. There's actually something called, that Angela was telling me about just this morning, a petition for rulemaking, where literally a citizen can petition for an executive branch agency to create a rule, and the agency at least has to answer you. They at least have to actually give you a reason why they either are adopting your rule or are not. You know, picture a situation where many people line up behind such an initiative. I will tell you that there are companies now out there. Some of you out there on the call today could be representing other companies that would be interested, that really now want to form a coalition to advocate for a far more business-friendly. And when I say business-friendly, I don't just mean, you know, those of you who have thousands and thousands of employees, but I mean a lot of the folks that I grew up with who had businesses with 5, 6, 7, 8 people, you know, small mom and pop shops. I think it's both of those who really need a more effective system for different reasons. But we really have a unique opportunity because, in fact, it's worked.
And Leon, we're doing this now. We've formed a coalition, and companies are welcome to join in and help us to move it forward. The whole notion of a petition for rulemaking is not that merely it is submitted to the agency and let the agency, if they find it distasteful, bury it, but rather that we alert Congress, we alert the public through media outreach that a rulemaking opportunity exists, and the crazy, unmanageable I-9 process can be handled in an electronic fashion that makes for authentication of the worker and for confirmation of the legitimacy of the documents. It all can be done, and it's a matter of people getting frustrated enough to say, this is absurd. We're devoting so many resources to an outdated process that still rests on microfiche.
So I want to just add, you know, I've been able to talk with the agencies and leadership in some cases, both at, well, all three of the agencies involved in this. And I think, you know, from ICE's perspective, and obviously this is just individuals, not as a collective, although probably it is a collective opinion, there's really no appetite at all for ICE to allow for an ongoing virtual. And trust me, you know, we've made the arguments, we've talked about everything from telemedicine to all the other ways that one can legitimize viewing documents virtually, and how, frankly, sometimes it's actually better because you can blow the documents up and all these things. Right now, today, with the current administration and the current leadership, I'm not seeing them want to move on this. I don't think that there's anything that they're going to say no to absolutely any possibility or a pilot program or something. I do think USCIS may have more of an appetite. And again, you know, these are the things that we are working on with several different clients to see, you know, how this could move forward. What does it look like? There's a lot of different ways that we could maybe temporarily, you know, pilot something, you know, perhaps in certain industries. I mean, there's a lot of ideas. And So for those of you, before we talk about litigation, because I want to leave time for questions, for those of you that are interested, I mean, now is the time. If you're sitting on this call, and I know we have a lot of AGCs and GCs on, and we have a lot of head of HR and even some people in policy groups. Now's the time, not to say we're going to wait for somebody else to do it, because, you all may get left behind, at least initially. But more importantly, collectively, we need a collective voice. We need to be able to say that the pandemic, COVID-19 has changed us all. Like, our lives are never going to be the same. So why would we think that I-9 should be the same? I mean, we have to be, reasonable. And we talked about this on our last webinar, to put HR managers in this, precarious situation where people have to come in, especially post, return to work. If we have a large number of people coming in, they have to touch the documents. They have to have them in their office. I mean, it's something that it's unacceptable. And so, everybody, legal, HR, and compliance have to come together here so that we can work on this and come up with these creative strategies.
And it's a two-prong, right? It's not just about regulation, but also litigation, where we've seen in the last couple of years the courts be really the place where we can push when the regulatory changes aren't happening properly. Leon, talk to us about some of the litigation issues, and in particular as well, we mentioned the EADs, the employment authorization documents, and the delays in card production, and as well for people who are being issued their green cards, the delays and the headache that's causing for employers trying to validate work authorization.
Yeah, so I think a lot of you have been seeing in the news that, in the context with all the other financial difficulties that USCIS is having, that is card production. And when we say card production at USCIS, we're talking about sort of banknote quality documents that have all kinds of sort of fraud-proofing features to them. Their card production contract has been significantly downgraded. That's resulted in severe delays in productions of both employment authorization documents and green cards, to a point where a number of employees are a number of workers are experiencing delays in getting their documents and are finding themselves unable to work without the documentation in hand. And so that's already leading to litigation. It's going to lead to more. We filed what's called the mandamus action, which basically forces a government authority to do what it's supposed to do. It's almost literally what mandamus means, make the government do what it's supposed to do. And
I
so
think, Leon, the point there is mandamus is not a complicated lawsuit. You just show the facts that the government had a legal obligation, an unreasonable amount of time has passed, and someone can get a solution relatively quickly. That can be done on an individual basis or a class action basis. And so there certainly are solutions there.
They're usually a few pages long. They can get filed in very, very quickly, and you'll usually get the other thing that's really interesting about it is certainly the pattern with USCIS is if you file it 9 times out of 10, a week later the agency will take the action, because even the lawyers don't want to waste time with something they know the agency is supposed to do. So that's an example. There's also going to be, I think, a lot of litigation to this point related to the remote I-9 permissions. And I think I was mentioning this earlier, where everybody's going to end up having done it a little bit differently. If ICE moves into a strong enforcement posture in the future, I think there's going to be a tremendous amount of pushback. In fact, that pushback, I think, will hasten the need to relax the process of physical inspection altogether. So I think that's another place where we could see really some pretty serious litigation, and the impact of which could be to sort of pressure the agency to change. But in the short term, employers are going to need to be ready to sort of defend themselves when the time comes that inspection activity resumes in earnest.
I think we can't forget about litigation, and it's a different form of litigation as well. I mean, if you're in the L&E field and you're used to wage and hour, class actions, this is not that. So this is manageable. It can be quick, and we can get results, especially when we have the mandamus filing. So really consider it. Talk to us, talk to counsel about it. I think we're going to move to Q&A, and before we do that, I'm going to provide the CLE code for those of you interested, and that's SS as in Seyfarth Shaw 8991. Again, that's SS Seyfarth Shaw 8991. So, Dawn, do we have questions?
We have a lot of questions, so I'm going to kind of quickly go through them. There were some questions, I'll throw them out. There were some questions regarding ICE's policy on virtual. Yes, they did note that the I-9s could be done via email or via fax or using videos. I'm not quite sure how you identify or how you verify the identity. So we're staying away from that, but that's what they said. In terms of the video, the virtual completion, I've asked whether or not you can complete Section 2 and view the documents before completing Section 1. The answer is no. You have to have that Section 1. It is a fineable offense to complete Section 2 before Section 1 because you can't look at the discrepancies in the information. So that has to be completed.
Dawn, let me jump in on one quickly.
Sure.
The question was, who pays the fine, the employer or the person completing the I-9 form? And that's clearly a fine that's payable by the employer, but that's not the only liability. And so false statements on a government form, penalties of perjury, serious criminal consequences can flow to the individual as well.
Absolutely, especially with fraudulent IDs. Okay, let's go on. Anyone can jump in on the questions. There's still questions on the skeleton crews in the office, and none are HR, or people in but none are HR. Basically, ICE in the July announcement, they changed the wording a little bit, and they said you have to be 100% remote. We feel comfortable in saying if there's a security guard sitting at the desk, that's still 100% remote, but they're basically saying if you have a skeleton crew in the office and somebody needs to be doing I-9s, or you can use authorized representative. Can the paper I-9 copy be signed electronically or signed? Does it have to be physically signed? So it has to be physically signed unless the electronic signature meets the digital signature requirements in the electronic I-9. Generally, it will not. That's a very simplified answer, and I would say if you are thinking about using Docusign or anything like that, you absolutely have to speak to counsel, because right now you cannot sign a paper I-9 electronically without having a lot of other things in play. I just want to tell you that while I'm on this webinar, and it's kind of funny, I just got my second email from a second agent saying, "Hey, how are you? Just want to follow up on the March," and literally they just came in within a half hour of each other. So clearly somebody must have gotten a directive today sent out to local offices to follow up on audits, because I just got two.
I think they heard you were going to be talking about these to a lot of people. Actually.
Or maybe they signed up to the webinar and they're listening to me. No, I'm joking.
Right.
Anyone want to take one? Otherwise, I'll keep going. There's a lot here we have.
Yeah, the one about people never returning to work. If they terminate and never show up, then you just have to note that in your memorandum where you're the archivist again, that this is what happened. The person resigned before they ever return to work. Or if remote work from home arrangements become permanent work from home arrangements, there had better be some good faith effort to try to get an I-9 completed in Section 2.
And I promise you ICE is going to come out on guidance on that. They're going to say that there's going to be a timeline. They're going to say, if you are still, we just saw Google saying they're not going to be coming back to work until July of 2021. I don't know what the date's going to be, but I promise you they're going to say, if you're not back to work by whatever this day is, this is, after things normalize and, God willing, everything else will slow down, then they're going to say, you may choose to keep your workforce. This is just my my guess, you can keep your workforce remote or keep the choice, but after this period of time, you're going to have to go to an authorized rep or have them just come in to complete the I-9. That's what I'm guessing. Anyone else want to take? Should we redo the I-9 once we see the physical forms? That's what we were talking about. You don't have to, but I do think having that signature under penalty of perjury would be a good idea. It might be cleaner to redo the physical forms if you're not the one who saw the original. If you're the one who saw the original documents and you're the one who completed the Form I-9 initially, I think you're fine to just follow the instructions and just put the information in the additional information box and keep it simply. Right to
I'll
work.
take one. If copies of Section 1 have been collected in the virtual process, should the employee re-sign and date Section 1 in order to obtain a wet ink signature? I don't think that's a good idea. I think that's putting a demand on an employee that they're not legally obliged to comply with. It invites the claim of discrimination or retaliation. I wouldn't do it.
But Angelo, that assumes, and that's what we talked about, you need that original signature. So you don't have to ask them again, but you're going to have to get them to send you. There was no relaxation of the Section 1. There's no ability to take a copy. So that's fine, but you need to get that original I-9. From them. So get the copy to run through E-Verify or whatever to make sure it's done, and also to be able to do Section 2. But you have to have arrangements to get that Section 1. That's what Mouse and I were talking about.
And that's a helpful distinction. I was talking about having someone come in and give a new wet signature, and that shouldn't be done.
Yeah, you don't. They're just to make them do it for. And some of the electronic I-9s, folks, that's going to be the problem. In order to do this new Section 2, some of them won't let you do a new Section 2 without doing a new Section 1. We have...
Right, and just remember, Docusign is not accepted. So we get that question a lot. It does have to be a copy of a wet signature that they're emailing you, faxing you, whatever, and then that's the protocol we were asking. How are you getting your Section 1? How are you getting your form? So instructions to them, when maybe they're mailing it to you, whatever it is, but you need to ultimately get that original. There was another question in there about a company who is having I-9s completed electronically through the add-on system, through the HRIs, but also doing hard copy Form I-9s. So that's a no. You're basically having someone complete an I-9 in two instances, and we're never doing that. So, and that's something, if we work with you already, reach out to the Seyfarth attorney that works with you on this to walk through what your process should be, because you really shouldn't have the same employee completing two I-9s.
All right. Well, thank you so much for attending. We really appreciate it. I think that'll be a wrap. Martha, do you want to repeat the code for everyone, and then?
Sure. It's SS as in Seyfarth Shaw 8991.
All right. Well, thank you all. We'll be announcing our next webinar on our blog. If you haven't signed up for it, please do. And everyone should stay safe. We'll talk with you all soon. Take care.
Bye-bye.
This concludes today's webinar. Thank you for attending.